We're ready? Ready? Good evening, everyone, and thank you for joining us again. As we are here tonight to swear in another officer, the Old Bridge Police Department. Her name is Sarah Salvaggio. Sarah is an Old Bridge resident. So tonight, along with Acting Chief Joe Mandola, we have the privilege of welcoming a new officer to the Old Bridge Police Department. Sarah attended Monmouth University and Brookdale Community College. Prior to Sarah being sworn in this evening, she was employed by the Monroe Township Police Department for several years as an accounts clerk and comes highly recommended from the Township of Monroe. And this has been a long time endeavor for you to get on the police department. Sarah took the written test and scored very well. She took the physical test, and I'm going to say that she did better than some of the men. So she deserves this opportunity. She's going to go to the academy till June. So she has her work cut out for you. And so please step forward, Sarah, and we will swear you in. We'll give it to our clerk. And again, I'd like to thank the police department for coming here tonight and all the hard work that's involved in getting recruits for our department. Thank you.
Okay. Do raise your right hand, left hand on the Bible, and repeat after me. I, Sarah Salvaggio, do solemnly swear that I will support the Constitution of the United States
that I will support Good evening. I'd like to welcome everyone and call to order the January 11th, 2022 Old Bridge Township Council meeting. Please stand for a Pledge of Allegiance. Please remain standing for a moment of silence and for our prayer. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. As tradition in our chamber, we stand for a moment to remember those who are protecting our freedoms, both here and abroad, for our first responders, and for those who made the ultimate sacrifice. A moment of silence, please. Our prayer, Mr. Pischetti.
Dear Lord, bless thy servants in the ministry of public affairs who serve thee in this chamber. Give us quiet minds and hearts that we may hear thy voice. Help us to know when to speak, when to be silent. Give us strength to oppose the wrong and uphold the right. And grant that we have a good conscience and soul at peace with thee and with one another. Amen.
Amen. Thank you. Please be seated.
Council President, we want to welcome special guest Sophia Shapiro.
Okay. Mr. De Palma?
Here.
Mr. Desai? Absent. Mr. Garcia?
Present.
Dr. Greenberg-Belli? Here. Mr. Murphy? Absent. Mr. Pasquetti?
Here.
Ms. Walker?
Here.
Council President Sohar?
Here. Thank you very much. Good evening and welcome, everyone. Tonight we will be starting with our consent agenda. I'd like to please.
This meeting is being held in conformance with the Open Public Meetings Act. Notice has been given to the newspaper, and the notice of meeting has been posted in public places. Next open public meeting of the council will be held on January 25th, 2020 at 7:30 p.m.
Okay, thank you very much. Okay, so we will be starting this evening with the consent agenda. I'd like to have a motion and a second, and we'll do the separation.
Second.
Okay, moved by Dr. Greenberg-Belli, second by Mr. Pasquetti. Okay, and now separations. We're going to separate C1.
I'd like to separate C2.
Okay, anyone else for separations? Okay, so we'll begin with C1, which is a resolution appointing acting municipal clerk for the Township of Old Bridge due to vacancy in the office. Do I have them?
Make a motion.
Second.
All right. And Mr. Shaw?
Thank you, Council President. Maureen, who is on the dais with us, has been appointed as an acting clerk due to, as Council President indicated, due to vacancy. Maureen is a resident of the town, and so we appreciate she's coming forward, assisting us while the vacancy exists. And then, obviously, we have a second resolution on the agenda to appoint Township Clerk, will be effective January 31st, 2022. Catherine Hutchinson. Council President, Catherine is in the audience.
Yes.
Catherine, you want to stand up and
be welcomed.
we do want to welcome. Just want to give you the idea, we went through as usual, our process of hiring, process of going through advertising, receiving resume, going through multiple interview process. Catherine was interviewed by myself, mayor, and the council president, along with our HR director. She also met with our township attorney. Whenever we interview somebody in the township clerk's office, always we lean on our township attorney who met with her. And I think the whole committee wholeheartedly supports, recommends council to appoint Catherine.
All right, thank you so much. I'd like to have a vote on that, please.
Second.
Okay, so it's moved by Dr. Greenberg Belli. It's second by Mrs. Walker.
Mr. De Palma?
Yes.
Mr. Desai is absent. Mr. Garcia?
Yes.
Dr. Greenberg Belli?
Yes.
Mr. Murphy is absent. Mr. Paschetti?
This is for C1 and C2?
C1.
Just C1, oh, yes.
Ms. Walker?
Yes.
Council President Sohar?
Yes, and welcome. Thank you so much. We're so happy to have you here.
Thank you.
Swear.
Yep. Absolutely. No, no.
May I have the Bible? 'Cause I can swear myself. I thank you so much.
I,
No,
left hand
right
down.
hand. I do it the other way.
I
I, Maureen Doherty,
do solemnly swear
do solemnly swear
that I will support the Constitution of the United States of America
that I will support the Constitution of the United States of America
and the Constitution of the State of New Jersey,
and the Constitution of the State of New Jersey,
and that I will bear true faith and allegiance to the same
and I will bear true faith and allegiance to the same
and to the governments established in the United States
and to the governments established in the United States
and in this state
and in this state,
under the authority of the people,
under the authority of the people.
and that I will faithfully,
impartially,
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 and justly
and justly
perform all the duties
perform all the duties
as acting municipal clerk
as acting municipal clerk
according to the best of my
to
ability.
the best of my ability.
So help me God.
So help me God.
Congratulations.
Thank you.
As I said before, welcome, welcome. We're very happy to have you here.
Thank you.
Okay, next will be the C2, the resolution appointing the municipal clerk for the Township of Old Bridge.
Move it.
Second.
Okay, we have a move by Mrs. Walker, second by Mr. De Palma.
Okay. Mr. De Palma?
Yes.
Mr. Desai is absent. Mr. Garcia?
Yes.
Dr. Greenberg Belli?
Yes.
Mr. Murphy is absent. Mr. Paschetti?
Yes.
Ms. Walker?
Yes.
Council President Sohar?
Yes. Okay, congratulations and welcome.
You want me to swear her in?
31st, yes, we will have the swearing in on the 31st. But we are very pleased to have you also. Thank you very much.
Swear her in now? Okay.
Okay, yeah, we'll wait till the 30, okay? All right, very good. Good. Okay, next will be, we did the consent agenda. Next will be the bill list, Mrs. Walker.
Accounts payable December 31st, 2021, $357,817.31. Accounts payable January 11th, 2022, $481,560.33. And that's all this week. There's no overtime.
Okay, do I have a motion?
Move it.
Okay, moved by Dr. Greenberg Belli, second by Mr. Paschetti.
Mr. De Palma?
Yes.
Mr. Desai is absent. Mr. Garcia?
Yes.
Dr. Greenberg Belli?
Yes.
Mr. Murphy is absent. Mr. Paschetti?
Yes.
Ms. Walker?
Yes.
Council President Sohar?
Yes. Okay, this evening was a little different due to the swearing in and the filling of the position for the clerk. So now we will vote for the consent agenda that was not separated, the balance. We had a motion and a second. So I'd like to call a roll call for the rest of the consent agenda.
Mr. De Palma?
Yes.
Mr. Desai is absent. Mr. Garcia?
Yes.
Dr. Greenberg Belli?
Yes.
Mr. Murphy is absent. Mr. Paschetti?
Yes.
Ms. Walker?
Yes.
Council President Sohar?
Yes. Okay, there are no ordinances for first reading this evening. Next will be report of the Township Clerk.
I do have a short report stating that the dog licensing will be delayed this year since we do not have the 2022 tags as of yet. We're hoping to get them in within the next 2 weeks, but we do ask residents to please just give the clerk's office a quick call to see if they are here so you don't have to make a trip for no reason.
Okay, so they're delayed. You don't know, though, for how
We're
long?
hoping to have them by February 1st,
By February.
but we ask that you just call and make sure.
Okay, yeah, rather than just come down. Okay, anyone else have any Questions for the clerk? No? Then I will take a motion to accept her report.
Move it.
Second?
Okay, moved by Dr. Greenberg Belli, second by Mr. Pasquetti.
Mr. De Palma?
Yes.
Mr. Desai is absent. Mr. Garcia?
Yes.
Dr. Greenberg Belli?
Yes.
Mr. Murphy is absent. Mr. Pasquetti?
Yes.
Ms. Walker?
Yes.
Council President Sohar?
Yes. Okay, thank you very much. Next will be our administrative report, Mr. Shaw. Oh, I'm sorry, the township attorney. Do you have one, Mr. Roselli?
No, you'll
No?
hear from me enough.
Okay. Okay, and then, of course, Mr. Shaw.
Thank you, Council President. While I don't have a short report, I do have a shorter report. Administrative report for January 11, 2022. Item number 1, COVID-19 testing update. Old Bridge High School is continuing its testing site for COVID-19. Testing occurs every Wednesday from 4 p.m. to 7 p.m. and every Saturday from 9 a.m. to 1 p.m. The high school's testing site will remain open within those hours contingent upon the number of tests in stocks. A new testing site will open at the beachfront substation of Route 35 North in Lawrence Harbor. We're hoping for the opening date to be this Sunday. This date will be confirmed on our website by the end of this week. There are also a walk-in COVID testing availability at Purity Diagnostic on Route 34, Excel Urgent Care on Route 516, and Texas Road Pharmacy on Route 537. We encourage everyone who has been exposed to the virus or showing symptoms to take advantage of this convenient location or offering services. Again, I just want to reiterate that we're working very hard to get the Lawrence Harbor site up and running at the substation. Just in case some logistic doesn't get done, it might be delayed, but we'll be posting the start on our social media and on our Facebook page. Item number 2, which is an important update, New Jersey State Highway Route 34 and Amboy Road traffic signal update. The NJDOT agreement for the construction of traffic signal at the intersection of New Jersey State Highway Route 34 and Amboy Road, Middlesex County Route 689, has been fully executed and final design documents completed. The District Attorney General will be forwarded the final agreement for execution. Once forwarded, the cost-sharing payment is received by the NJDOT from the Township. Authorization will be sent for the construction of the traffic signal to New Jersey DOT construction personnel. I just wanted to make sure that the council and the public is made aware of all the steps that are going on with the traffic signal.
Thank you, Mr. Shaw. Does anyone have any comments or questions for Mr. Shaw? Okay, Mr. De Palma?
That's, Mr. Shaw, the testing that's going to happen in Lawrence Harbor, is there going to actually be dates? Is it going to be like Monday, Wednesday, or is it going to be?
We're looking at Wednesday and Sunday.
Okay.
Those are the dates right now, but it will all be announced once the site is up and ready to go, because they did put the trailer right now. They have, we have the Public Works has already provided generator there, but they need to go to the permitting process before they can start operation.
Okay.
So we're waiting for that to happen, and then it will start. But the dates looks like Wednesday and Sunday based on their availability of personnel.
Okay, excellent. And thank you for the update on the traffic light on Route 34 in Amboy.
Okay, does anyone else have a comment? Mr. Garcia?
Yes, Mr. Shaw, do we have a time frame for the signal?
It will be same time frame that we have currently at the high school, Wednesday at 9 a.m. to 1 p.m. Wednesday at 4 to 7, and Saturday from 9 a.m. to 1 p.m. It hasn't been, I just want to caution, it hasn't been finalized because of the testing company's personnel availability. So, but before this weekend, we'll have something posted on website, and I will notify council of all the detail.
And one more question regarding the signal, traffic signal. Is there a time frame on that?
Unfortunately, no, because we're dependent on New Jersey State and DOT, so I don't want to mislead you, but our township engineer, Nicole Shapiro, is constantly on with the state and the county. In fact, this agreement that we needed from the county, we just found out that, we had to make several phone calls and contact to get the county to get the agreement done, complete, and then send it to the state. So, but we're hoping that it gets done as soon as possible.
Okay, thank you.
Okay, all right. Okay, I also just want to thank Mrs. Shapiro and Himanshu for all the vigilance in keeping up with this project, and it's not an easy thing to do. As Mr. Shaw said, things come 11th hour. You weren't aware of certain things, you weren't given notice, and I do appreciate that this is on your radar and that both of you have been working really very hard to try to get this finally accomplished, and really thank you both so much. Okay, anyone else?
I can't believe this is actually coming to fruition after all these years. I just hope it comes to fruition before I'm 90. I think we've been working on this for 20-something years now. I just want to thank everyone for all their hard work. I'm really hopeful this time.
Yeah, we're very anxious, both of us, her and I. Okay, if anyone else has no questions, then I'll take a motion.
Move it.
Second.
Okay, moved by Dr. Greenberg Belli, second by Mr. De Palma.
Mr. De Palma?
Yes.
Mr. Desai is absent. Mr. Garcia?
Yes.
Dr. Greenberg Belli?
Yes.
Mr. Murphy is absent. Mr. Pasquetti?
Yes.
Ms. Walker?
Yes.
Council President Sohar?
Yes, and thank you again, Mr. Shaw. Okay, next will be public comment on any subject matter for a maximum period of 3 minutes. Individuals who wish to be heard, one at a time. Go ahead, and she has something to read as well. Thank you.
The public comment portion of our meeting is to allow the public to bring to the council's attention their concerns and comments. This section is open for any topic or items in the consent agenda. In accordance with NJSA 10:4-12A and the Old Bridge Rules of Council, the council asks the public to limit their comments to 3 minutes or less. Only one member of the public should approach to speak to the council at a time. The council will respect the public's time by refraining any comment until the speaker has finished with their allotted time. It should be further noticed that the public comment portion of our meeting is not structured as a question and answer session. If a member of the public has questions they seek answers to, an appointment can be made with the corresponding department's office during regular business hours. The township clerk will regulate the time during the comment portion of our meeting.
Okay, thank you very much. Okay, is there anyone in the public who wishes to be heard? You can come forward now, please, if you want to come first, sir. Okay, good evening.
Good evening, Council. Charles Cradaville. I'm the Central Jersey Organizer for Food and Water Watch. Just to update you.
I'm sorry, could you spell your last name for me, please?
Absolutely. Kratovil. And I'm with Food and Water Watch. Wanted to inform you that we did submit 230 additional signatures, 3 times the amount required to bring the clean energy ordinance to you. And just came here, not to put the new interim clerk on the spot right away, but I did want to ask if there was any update on that, and as far as the timing for when the public hearing may be held, and just also want to confirm that I can communicate with you through the clerk at oldbridge.com email address. If you could
The
just...
signatures have been received and they have been verified. The 75 extra that were required have been received. There was more, but we accepted the 75.
Terrific. Well, that's wonderful. Can you tell me when the hearing might be held?
We're anticipating to have it on the agenda for the January 25th meeting. Okay?
Wonderful.
For introduction, well, for public hearing, because it's already deemed introduced.
Great. So pleased to hear that update. Thank you so much. And I do want to confirm that I did send all of you an email tonight, and I remain available to answer any questions you may have about the ordinance. And I want to encourage everybody who has questions about it or wants to learn more, to come out on January 25th and hopefully speak in support of transitioning the township to 100% renewable energy by the decade. This is something we can do. It's being done in other towns here in Middlesex County, and would love to have Old Bridge join the clean energy revolution. Thank you.
Good evening. Is there anyone else in the public who wishes to be heard? You can come forward, sir, please. Good evening.
How are you?
Good. If you could state your name, please, for the record. And
My name is Ron Simone. I live at 98 Cottrell Road. I wanted to come in and ask and see what I could do. I've reached out to the town. I've reached out to the county. And like I said, I live at 98 Cottrell, and I've had right near the ex-captain of police and fire officer, and we keep having people drive onto our properties, smash into our vehicles, and actually somebody, in the past 10 years, I've had 9 people crashing on my property, one that drove through my house and knocked my house down. And now, as of Saturday, this past Saturday just passed, somebody jumped the curb, hit the guardrail, landed on my property again, and I'm sitting home with my children all the time and my wife, and I don't understand how I just had to rebuild my house after 2 years from somebody actually literally driving through my house. And I've asked for a guardrail to be put up 1,000 times, or they keep telling me they're straightening the road. They keep telling me they're going to put a guardrail up. Nothing ever happens. Just built my house again, and it happened again. So I'm reaching out to see what I have to do in order to get somebody to do something.
well, maybe you could make an appointment with our.
Council President, I think gentleman did come to our office, left a message. I wasn't there. We collected information. I have Township Engineer Nicole Shapiro, and this evening she wrote a letter to the county engineer about additional guardrail to be installed his property. So as soon as we get a response from the county, we'll notify you of what their response is. Just so that you know, it's a county road, it's not a township road.
Well,
So we don't have authority to just install something on it.
What I keep hearing, excuse me, but what I keep hearing is Cottrell Road is the town road and Spring Hill is county road. So I keep getting back and forth, one person blaming the next person, the other person blaming the next person, and it's getting tiring to hear.
I can tell you that Cottrell is a county road, and I will share the email that the township engineer did send it to the county about it. But yes, Cottrell is the county road. Cottrell Road is a county road, not the township road.
Okay, so what do I have to do myself in order to get this to move forward?
We'll follow up with the county. We'll keep you abreast of what the response is getting, but I don't know who is giving you that information that Cottrell is not the county road. You let me know if you have a specific person that advise you, and we'll correct the information with them, but it is a county road, and we're gonna be vigilant with the county in getting things done so that your property is safe.
Okay. Yeah, Mrs. Shapiro, if she said she sent an email out, then I know she did. So if you want, to speak with her, that's up to you. But I think she'll take care of the situation for you.
Thank you.
Okay. Is there anyone else in the public who wishes to be heard? Good evening.
I'm Kevin Wire. I'm back with some letters from various lawyers involved.
Could you spell your last name for me, please?
W-Y-E-R. Okay. This one? Okay, good enough.
Excuse me, Mr. Wire, I know you were at the last council meeting, and, you had presented statements relative to one of the council members, and not knowing what the topic was, I think you were given some leeway, but what I advised you last time, this is a time to discuss township-related business.
Well, it is township.
Well, actually, it's not. There's.
Well,
from
you what
made
a lot of statements at the last meeting.
Right, but there were personal there was.
No, a lot of it ain't personal.
Excuse me. No, it was all personal.
I didn't get personal.
No, the information that you gave was personal information.
All right, well, I have
It's
letters
not-
here from lawyers.
I know, but it's not relative to what the township does or township business.
All right,
I mean,
well,
those are clearly two different things.
so what are you trying to say? You're saying I can't read this?
Well, depending on what the topic is, if you're going to go about and make some of the same comments that you did last time.
No, they're
it
not
wouldn't-
the same.
It wouldn't be appropriate.
They're not the
If
same.
you want to have questions of the governing body relative to things that are going on in the township and addressing the township issues related to that and township business, sure, that's fine. But if it's a
Well-
matter of, ad hominem attacks against a council member,
You can say his name. His name's John Murphy.
well, okay, I don't know who you're going to talk about, so I can't
Well, I told him
presume
to talk about it. I don't,
right,
you know,
so,
had to leave
again-
school early to come say
Right,
something,
so
so.
again, I wouldn't think it would be appropriate with relative to those types of items.
Well, I want to read what I have, and, you know, I mean, it is what it is. I got about 100 phone calls encouraging me to come back here, all from Old Bridge voters, about what I said, and that I should follow up and do what I'm doing. So that's why I'm here. And, you know, next month, if I can't read my letter, I'm gonna bring my sons, and I'm gonna bring a lot of other people, and I'll fill this whole room. So it is what it is at this point. You know, the man stole $100,000 from my wife with his girlfriend, and that's a fact. And you have him sitting on your council. So I'd like to read what I have to say, and I'm not, you know, if you don't let me, I'll come here with everybody I can get on the phone.
Again, I don't know what you're going to say, so
Well, then let me say it, and
I'm
then
just cautioning you relative to what's appropriate.
I'm not saying anything that's not true.
I don't know that. I'm not
Well,
judging you one way or
I'm
another.
telling you that. I don't lie. It's not my
I'm
nature.
not saying you do.
Okay.
I'm just not privy to the information.
All right, well,
or-
I
or the
have things
facts.
that the lawyers said, and it contradicts what John Murphy said at the last meeting. It backs up everything I said, so that's why I'm here. Because when he gets up and says I'm lying and everything's bull crap, and, you know, the whole spiel that he went through, and then after the thing was all over, he got back up and got personal about things, which shouldn't have been said, but he got to say it. Okay, this man's been lying about me and my family for quite some time. Okay, so I have to read this, and it is what it is.
Go ahead.
My name's Kevin Wire, back with some letters from various lawyers involved that contradict the statements John Murphy made at the 1-4 meeting. He stated this is all BS, it's all settled, they found nothing, it's dropped, and Kevin's lawyer got mad that I filed a complaint against him. It's all lies. I will read from the lawyer's letters. I spoke to your client for over a half an hour over the weekend, and he reiterated his displeasure in the dissipation of funds, for which I heartily concur. However, suing two people and getting a judgment against them, even though they are essentially judgment-proof, and assisting the investigation of a criminal complaint is about the best I can do. I have made an accounting of the losses, and they are very carefully detailed in the OSC, and that was filed and served on both councils and on Kevin. We did settle a suit in Chancery, and it will result in a judgment against both Diane and John and calls for a monthly payment. This should help with Kathy's expenses. And referring to John and Diane as essentially judgment-proof means they don't own anything. An investigation of the criminal complaint is ongoing. The monthly payment, from what I understand, is $1,500 a month for 5 years. That's $90,000. And the amount is higher than $90,000 that John and Diane stole. Now I'll read from John Murphy's guardianship lawyer, Kimberly A. Fierro. Recently, Mr. Murphy made certain statements to me during a telephone conference call, which prompted me to make further inquiry and request certain documentation related to these statements. Upon review of the requested information, I communicated with the client in writing, provided legal advice regarding my concerns, and offered to set up a time to speak with the client via Zoom video conferencing. A meeting was scheduled, but Mr. Murphy refused to participate. I again communicated with the client in writing regarding my obligations and his options moving forward. The client has refused to cooperate and insists on taking action which I have fundamental disagreements with. Furthermore, I previously informed the defendants that in the event of such an eventuality as described above, I would be obligated to withdraw from further representation. Given these facts, I do not believe I can continue to represent the petitioner in this matter. Such continued representation conflicts with the New Jersey rules of professional conduct. She told John Murphy that she would not represent him because he told her he was taking her money. After I left the last meeting, John went on to run his mouth because he knows he's caught. I expect the council to have an ethics investigation into his behavior, and again, I state he's unfit for his council seat. I have received many calls, mostly from Old Bridge residents, who have encouraged me to get the truth out about John and Diane. They showed support for me and my wife, Kathy. John has run up lawyer bills I've been paying. He has deep pockets when it's other people's money. The lawyers also state that I have a defamation lawsuit against John, which I plan to pursue. I would like to thank the council for their time and patience on this matter, and I'd like to add that they stole $100,000 in 10 months. Thank you very much.
Thank you.
Anything? No? Okay, thank you.
All right, is there anyone else in the public who wishes to be heard? Good evening.
Good evening. Okay, I am Sal Giordano, one of the 9 members of the Old Bridge Board of Education.
I'm sorry, I can't hear you.
Oh, yes. It's on. Okay, is this good? Okay, great. Yes, I'm Sal. Okay, great. I'm Sal Giordano. I'm one of the 9 members on the Old Bridge Board of Education. And first, I would like to congratulate Mr. Garcia and Mr. Desai for being elected for the very first time to the council, and all the other board members that were elected. We do have a Board of Education meeting tonight, and I am not there right now because I was kicked out for not wearing the obedience mask that the governor requires people to wear when they're in a school building. And I just want the public to know that this action from the governor was done in complete violation of what the legislator wanted them to do. They voted against his powers to do that. And I don't know if we have a power locally, but we should be passing resolutions that basically denounce what he's been doing with his excessive use of executive orders that have nothing to do with health and safety, but rather about control. So that's all I have to say. I'll be here after the meeting to congratulate the award winners, maybe talk to the public or anybody here. But yeah, that's just my complaint. I very respectful, civil disobedience, and I was removed, and that's it. So that's it. Yeah, it's fine.
Okay.
And that's it. Good luck.
All
Maybe
right.
I'll-
Thank you very much.
yes.
Good luck to you as well. Thank you.
Thank you. Oh, wait, sorry. I'd also like to apologize for anybody that was shocked by what I did or thinks that was disrespectful, and also to the people before me that had more important individual issues. I just thought this should be brought up.
Thank you for your time. Is there anyone else in the public who wishes to be heard? Come forward, please.
Nina Chochnowitz, West Greystone Road.
Could you spell your last name for me, please?
Jochnowitz. By the way, welcome to the team. I would like the council to reconsider their 3-minute time limit, because obviously between the back and forth that have gone through this evening, each person has gone more than 3 minutes, some of them over 5.5 minutes. And while I do understand there is a time limit, Mr. Rosselli, correct, to the evening, I think that you guys should go back to the old rule, which was 5 minutes. Why don't you consider it, Mary? Thank you.
Okay. Is there anyone else in the public who wishes to be heard? Seeing no hands, I will close the public portion and we'll now go to council comments. Can you call the roll for council comments, please?
Okay. Mr. De Palma?
Yes, just real quick, I'll just be the broken record again. I saw another accident just today, not in our town, but in an adjoining town. Please slow down. Like I'm gonna be a broken record every single time, right? You know, we have to just watch out for each other, obey the traffic laws, make sure you're safe. An extra 30 seconds, an extra minute to get somewhere is not a big deal, right? Please slow down, right? The other thing, for the traffic light on Route 34, Mr. Shaw, thank you again for the update. Hopefully, we can get this going before I turn 90, as Debbie's looking forward to before her 90, but obviously that's something that's important, especially for that one single road. I think I've said it before in the past. I've actually had a pretty severe accident there before I was on council. So it is a very dangerous road that hopefully will help. It'll help the folks that are on other streets as well. So thank you for following up, and hopefully we can get this resolved as soon as possible. Thank you.
Mr. Desai is absent. Mr. Garcia?
I just have a quick comment. Basically, I just want to say, everybody, stay warm, be safe, and like Eric said, I know there's been a few accidents on 35 past week. Everybody should slow down. Those are bad accidents on 35. I'm sure they're all over the place. All the ice we had the other day, people are still traveling as if there's no issues out there. We need to slow down. Let's be safe. And like I said, stay warm, and thank you.
Dr. Greenberg, Belli?
Yes, first of all, welcome and thank you for your assistance.
Thank you.
And I'd like to thank the road department. The town was cleaned up pretty good for our first snowstorm. I didn't get any complaints. Everyone was happy. And really, during this time of year, we just have to be more vigilant and safe. Everyone healthy and happy.
Mr. Murphy is absent. Mr. Paschetti?
No comment, thank you.
Ms. Walker?
I just wanted to again say how happy I am about the light on 34. I just can't believe it. I just hope a lot of people at home are listening, because I'm constantly contacted by people in the area. So when I get home, I have a lot of emails to write to people to tell them the light's actually coming. Thank you, Nicole, for all your hard work.
Council President Sohar?
Yes, thank you. And again, just to reiterate, we are very, very happy about that light. Obviously, you can tell it's been a long time. So thank you both for all the hard work. It really will make a difference at that intersection. I think, Mr. De Palma talked about safety and Mr. Garcia, and I think that this is part of it to ensure that we have much more safety in that area for everyone. Thank you very much. Okay, next will be our hearing, Appeal of Zoning Board Application 12-2021Z. Mr. Rizzo.
Yeah. Madam President, just want to confirm, I think Mr. Holub. Hey, Mark Selly, how are you?
May I remove Matt?
Yeah, that's fine. Yeah.
I'm gonna be up here.
Yeah, that's fine. Hey,
H-O-L-U-B.
how are you?
Tony Vignolo's office.
All right, yep. And Mr. Gazarovski's here as well. And is that your court reporter in the back, or no?
He's our videographer.
All right.
Correct.
And then what are you going to transcribe from that?
Yeah,
All right.
he's gonna video it and transcribe it. I heard there's a limitation or not as many court reporters available.
Oh, really? How about that?
So, he is here. I do have Madam President's permission if he could see if he could run the audio, just so, I know you guys have audio.
We do. We have audio. Yeah, we have audio now.
He's gonna run audio here, so he has the audio too as well, so when he transcribes it, he could effectively hear what's
Right. And you'll right. If that, I mean, obviously, if you need a copy, depending on yours, if you need a copy of ours, we'll make it available.
Sure, we just wanted to
Right.
double up and make sure everything is available.
And this, if I could, you'll make a copy of the transcripts available to the township? Fine, yeah, great. Right. I mean, actually, under the statute, we can make the recording available. If someone asks, they'll have to pay for it, but they're going to have their copy, so it doesn't really matter.
He's gonna cut it into a movie?
Yeah.
Soundtrack, so if you got one.
Oh, my God. Yep, not a problem.
Take your time, just
Yep, no problem.
Sure, first name is Jay, J-A-Y, last name is Holub, H-O-L-U-B. U-B as in boy. Another question, Madam President, would it be acceptable, because earlier we were directed to be in the back because of the people in the audience? Okay, if he's not intrusive and that doesn't block anything, thank you very much, I appreciate that.
Well, unless you can move a chair, there you go. Just move a chair, and then you might be able to fit inside there.
I have a card if that would be.
Mark, chairs doesn't move.
All right, well, I guess you can't move a chair.
Mr. Roselli, I did bring copies of a transcript for everyone. You have them? I wasn't sure. Thank you.
I'm not sure if he'll make a copy of the transcript available. Mr. Gazarovski, you guys, if you need it, you'll have to figure that out.
I think at this point, everyone has a copy.
No, of this hearing. Relax. Yeah. Just by way of background, if you recall, this portion of the meeting's been reserved for a review of the Zoning Board of Adjustment record in connection with an appeal that was filed by William Sarah relative to an application that was heard by the Zoning Board under application number 12-2021-Z. The original decision was rendered back in July of 2021. The notice of decision was published on October 14th, 2021. A written appeal was filed and delivered with the Township Clerk on October 15th, 2021. I would note that this appeal process is set forth in the Township Code at section 250-18 and under the municipal land use law under 40:55D-17. These types of appeals are not common. I've encountered one previously in another municipality, and typically what the basis of the appeal is the fact that the Zoning Board of Adjustment granted a use variance. And we have with us this evening counsel for the appellant, Mr. Sarah Skazrowski, and the counsel for the applicant, Mr. Holub. And I think as a procedural matter, a couple of things. I know today or this morning we had received a written argument from Mr. Gazarowski's office in the form of a letter brief setting forth his client's position, and then later in the day we received a written letter brief from Mr. Holub relative to his client's position as well. And I'm not, if council does, did council receive, I know they came later today, I'm not sure if you guys you've received it, have had an opportunity to review them, but those were submitted as well. Now, just as a procedural matter, we'll go over some things, but again, this is a de novo review of the zoning board's record by this body, meaning that, as I had stated previously, there was a record that was developed at the zoning board, which all of you had received. That record included the initial application, a use variance sketch, a survey, a traffic report, an architectural plan set, the transcript from that hearing. There were 2 waiver letters. There was a review letter by ERI. There was a review memo by the township planner. There was a memo by the fire subcode official. There was the resolution by the zoning board. There was a traffic report submitted by the engineers for the applicant, and there was a community impact statement also submitted by the applicant's planner. A de novo review, just from a perspective, is this board will listen to the arguments that'll be presented by counsel for each of the respective parties, but you're reviewing the record as if it's being presented to you. There's no live witnesses, there'll be no additional testimony, but your decisions that you make will only be based upon the record that was generated before the zoning board. As an example, just imagine as if you were the zoning board having to make the decision, but instead of the live testimony, it's based upon the written transcript and the record that all of you had received. There may, what I've done previously, obviously, I have asked the appellant to present their case initially, and then the applicant can present their case. If any council members have questions, they can certainly proffer those questions to council based upon their arguments. Before we begin, though, there's a procedural matter. As part of Mr. Hollob's submission, he did include a motion to dismiss. So as a preliminary matter, I don't know if Mr. Gazarovski had an opportunity to review that. I would just, Mr. Howell will address that part first, and then I'll give Mr. Gazarovski an opportunity to respond, and then I'm not the decision maker, but given that these are legal arguments, I think it would be appropriate for me at least to weigh in as to the the motion itself. So, Mr. Howell. You can sit down, Jay. You don't have to stand up. Yeah, it'll be easier. And I think those mics, they're wireless, so you can move it closer to you. Are they on? All right.
1, 2, 3. Okay. Good evening, Madam President, esteemed members of the council. As Mr. Roselli indicated, I did submit a submission earlier in the day. I do have copies here with me. If any member of the board requires a copy, if you do, please let me know, and I'd be more than happy to distribute that out to anyone that needs a copy. Ron, if you have a copy too or need one, let me know. Excellent, thank you. The preliminary matter was a notice of motion to dismiss. It was basically based upon the defectiveness of the notice that was filed by the appellant in this matter. As stated, the original hearing was back on July 15th, 2021. Thereafter, a notice was submitted on August 26th, 2021 from the appellant, Mr. Serra. At that point in time, it didn't indicate what the grounds were for the notice of appeal. Looking at the municipal ordinance that was referred to by Mr. Roselli, which is 250-18A, as well as the statutory regulation of 40:55D-17A, it indicates that the notice must specify what the grounds are for the appeal. The appeal indicated that the township planner and township engineer had recommended that the variance application not be granted. There's some issues with that indication, as well as the specificity with the quality of the notice. On the same date, the township clerk apparently, in its letter dated August 26, 2021, notified the appellant that they had consulted with your legal department and that they were providing to him a copy of the municipal ordinance 250-18, advising him that there were certain requirements that must be satisfied. And then they requested that he review it and he comply with the ordinance. Subsequent to that, the resolution was passed on October 7th, 2021. Thereafter, the appellant again filed a notice of appeal on October 15th, 2021, using the similar, if not identical, language that was originally contained in the defective notice. Without consulting the municipal ordinance or the suggestion of the township clerk, the ground for the reason for the appeal was not specifically stated in there as required by the notice. Furthermore, under those statutes, there's a requirement that the transcript of the hearing be obtained by the appellant, either through a deposit of $50 or an estimated cost, whichever is less. and that must be done, as it indicates it shall be done within 5 days of the filing of the notice of appeal. To my knowledge, that has not been done. Additionally, there's another portion of the statute and the ordinance that requires within 35 days of the notice of appeal, if the appellant otherwise obtains a copy of the transcript, it must be served upon the municipal clerk. Again, there was indication that this was never done, and under the municipal ordinance as well as the statute, it indicates that if it's not done, it's considered lack of prosecution, and the matter may be dismissed by the board. Lastly, there is an argument that we made indicating that there was no allegation provided by the appellant that he is an interested party in this matter. An interested party is defined by NJSA 4055-4 under the MLUL, where it indicates that the appellant right, use, acquire, or enjoyment of property should be affected by the grant of the variance. There's been no allegation or substantiation of that point. Additionally, I also note that on the zoning variance requirements of giving property owners within 200 feet of the subject site notice of the application for variance, this appellant is not on that 200-foot list of property owners. Additionally, I note that for the board, this appellant was not at the July 15, 2021 hearing, nor was any objection made during the public portion of that hearing by the appellant as to an objection to this matter. With that said, I've filed my motion to dismiss based upon those three bases. Thank you.
Yeah, let me respond. Let me start from the bottom and work my way up. With regard to this issue of his being an interested party, number one, it's true that my client was not present at that hearing. However, being present at the meeting is not the criteria for being able to file an appeal. Number two, it's also true that my client does not own property within 200 feet. However, he is in fact a resident of Old Bridge. He owns numerous properties in Old Bridge, either in his name, his wife's name, or in entities which he owns. As a matter of fact, he owns one parcel which is located on Route 34. Whether it's a mile or a half a mile or a quarter of a mile, it's irrelevant. So long as that property is in Old Bridge, he is in fact an interested party, both under the MLUL as well as case law. So that would be my response to the last issue raised by my adversary. Now, if the board wants to take these one by one or have me go through all of them at once, which...
Why don't you address, and then I'll weigh in on my thoughts.
With regard to the transcript, I, of course, became involved in this case approximately a week before the Christmas holidays. My client brought to me the paperwork which he had submitted to the board, to the clerk, and that did include copies of the videos of the hearings. I don't know whether he delivered, in addition to the videos, the actual transcripts, but the videos were presented to this board. The clerk did not say, what you've submitted is inadequate, we want more. I spoke to Mr. Roselli this evening, and as a caution, I did bring copies of the transcripts with me this evening. If any board member does not have a copy, he indicated to me that the board did in fact have transcripts. So while my client perhaps didn't comply with the exact letter, he did in fact provide the documentation necessary for you to make a decision this evening. With regard to the notice, my understanding is that the original notice was filed sometime back in August the 26th. Having said that, I did in fact speak with Mr. Testino when I first became involved, because I wanted to have a courtesy from him, which he graciously extended to me to allow me to go on vacation in Florida. And I still have some remnants of my suntan, which should be gone shortly. I'll have to wait another year to get a tan again. But no issue was raised, nor was, I mean, the application by my client was accepted, scheduling a hearing in question, so I would submit that there really is no merit to that argument as well. And perhaps looking at it, starting with the interested party, I think that's the least effective argument to be made. The transcript, there's been compliance, and again, with regard to the notice, we're here this evening after my client having filed these papers, and they're being accepted. So that's my argument.
Does anybody on council have any questions for the, so again,
May I just
sure, go ahead.
make one
Yeah,
point?
you can
and
respond,
I'll be
absolutely,
brief
yep.
about it.
Absolutely.
With regard to the final argument made by my adversary concerning the grounds, whether or not they were stated properly or improperly by the appellant, I just want a note for the board. This puts my client at a disadvantage as to not knowing why the appeal is being filed. Again, in the August 26th letter, as well as the October 25th letter, the appellant indicated that the appeal was based upon the recommendation of the planner and the engineer to not approve the variances. In a thorough review and analysis of both the transcript from the hearing below, as well as the documentation provided by each, the township planner and the township engineer, there was no recommendation found in either of those pieces of information. So again, if you look at it from the standpoint that the appellant's alleging that the engineer and the township planner recommended not to accept this or grant the variance when this information is not existing there, the notice really is void of any ground or basis for bringing this before this council. And the statute, as well as the municipal ordinance, which mirrors the statute, indicates that they must specify what the reason is, and there is no reason that was provided in the notice.
I'd like to respond to that. First, I think with regard to the engineer did in fact point out I'm sorry. The engineer did in fact point out the necessary variances, and more importantly, to a lot now, the need for a use variance. If you look at pages 55 and 56, the planner very specifically referred to the fact that in the master plan, as well as the re-examination of the master plan, that this was not a permitted use. She further pointed out that it had been the governing body's policy to discourage additional residential uses in this particular area, pointing out that the governing body had stated that there was an abundance of rental properties in the township of Old Bridge. So when we look at the master plan as well as the re-examination of the master plan, now both of those documents would be prepared by the planner. They would be reviewed by the planning board, but ultimately a decision with regard to them would be by this governing body. So this governing body, or its predecessor, back in the year 2019 and 2020, specifically in the 2017 plan and the 2020 re-examination plan, very clearly pointed out that the OG zone, general office zone, should be evaluated for alternate non-residential uses. Now, if it was in fact the planner or the governing body was recommending that this property in question in this zone permit residential units, they would have said that, except actually what they did say, they're looking for non-residential uses. So there was in fact evidence in the record by way of comments by both the engineer and the planner significantly establishing the fact that it was their recommendation as adopted by the planning board and the governing body that this property not be used for apartments or residential use.
So just so I could, so obviously the process that's set forth in the ordinance and in the statute in the MLUL doesn't contemplate a notion to dismiss. And to me, it would be incumbent for this council to make legal determinations that probably beyond their purview, almost requiring me as a township attorney to give you certain guidance with that. But I think a practical approach is this. Mr. Hollop's correct. The notice of appeal was filed. The grounds that it specified said that because I'm paraphrasing, the planner and the engineer thought it shouldn't be approved. Now, obviously, at the time Mr. Sarah filed that, he was pro se, meaning he didn't have counsel. I would think that if I were a judge sitting in a court, that usually that they'll give a pro se party some leeway. That being said, the ordinance and the statute set forth the basis for the appeal. So an interested party appeals the final decision of the zoning board when a use variance or D variance is granted. This was a bifurcated application at the zoning board, meaning that the only issue was the granting of the D variances, right? There was a D1 and a D5 variance. So while the initial appeal doesn't completely articulate the fact that a ground, so to speak, I think it would be incumbent, because initially the individual was not represented by counsel. You can certainly glean from the record and the statute and the ordinance that he's appealing the fact that the use variance was granted, and he disagreed with respect to the use that was granted. The other thing I would say is that obviously recognizing his inability, I guess, to pursue it, he did retain counsel. Counsel's been involved, as Mr. Gazarovski, sometime before Christmas. And I think, and then certainly Mr. Testino engaged counsel as well. So I think with respect to that aspect, while it might be technically correct, I think at this point, given that both parties have submitted a written argument, that we know the position. I don't think that the applicant in this instance will be prejudiced in any way. The other thing is with respect to the transcript, while it's true a deposit wasn't made, there's also a provision in the ordinance that talks about if the transcript is on file with the Township Planning or Zoning Board, the applicant shall be obligated to pay the standard cost of photocopy fees. Otherwise, the appeal may be dismissed for failure to prosecute. The unique thing about the transcript was that the transcript itself was part of the zoning board minutes. So anybody could obtain a copy of the transcript by going onto the township's website and getting the minute from those meetings, because my understanding, what I was told, was that that's what the zoning board does. They include the transcripts as part of their minutes, and then typically the board attorney utilizes that transcript to formulate his resolutions that's adopted. So as a practical matter, when you have public minutes that include the transcript, it would seem, well, I know obviously what the statute says, but we already had the transcripts as part of the minutes that were available to anybody, and to require that there was no need for the deposit because the transcript already existed, and they were part of the minutes. So there was real no need for the payment of that fee. And the bottom line is that we all have the transcript, and it was presented to counsel, was presented to Mr. Testino before he had counsel involved, and it was presented to Mr. Serra before he had counsel involved. And then finally, with respect to the issue of interested party, as Mr. Hollop referenced, right, the definition of interested party in the township ordinance and the statute are the same. But I think over time, courts have interpreted interested party to be pretty broad in land use decisions. And then this evening, obviously, there was reference to the fact that aside from being a resident in the township, that the appellant does own property in the township, some on Route 34. And my feeling would be is that ultimately that issue of interested party, a court could easily find that there's an interested party. those are my thoughts on the topic. As I said, it's difficult for this board because the statute and the ordinance doesn't contemplate a motion to dismiss. Certainly, by raising it now, Mr. Halber's client, depending on what the outcome is, doesn't lose that right to raise that later on if in fact, depending on the decision. But I think as a practical matter, being that I think we all know what the issues are, and I think some of these are more technical in nature, it would, for this board to render an ultimate decision, I mean, you can, usually he's filing a motion, council can determine whether or not to grant the motion to dismiss based upon what you had heard. I don't know if you have any questions. Anybody have any questions? So with that being said, Mr. Howell, would you want the council to rule on your motion to dismiss?
I would prefer that a ruling be made. And I don't know how it's going to go down.
Right, me either.
My other consideration too is, thank you. My preference would be for a ruling now, okay? And as I don't know which way it's going to go, it may lead to the arguments of the actual application in the record below. And again, I do recognize the fact that all this information was provided to you earlier today. It seems like everyone has received my paperwork, as well as Mr. Gazarovski's paperwork. I don't want to rush it because there's a lot of stuff there to digest, okay? I don't want to rush it and force the council into a determination if they feel more comfortable to reserve. I would like, a complete and thorough and thoughtful determination of this issue. And I don't mind arguing both arguments just as a backup, but that is my position.
Right, so let me just ask council, I mean, obviously this was raised. Does council feel comfortable hearing the arguments of council and my thoughts on the issue of whether or not to grant the motion to dismiss? Or as Mr. Howell had indicated, that's something that you can reserve decision on, not render a decision. Hear the arguments, go into the record, hear what the arguments are, and then, depending on what that is and whether or not you get to make a decision tonight on that or not, I don't know. So I'm not sure how long this is going to take.
May I ask a question? I'm not really clear. Mr. Hollop is saying he doesn't want the board to decide that issue prior to the hearing of the case, but to reserve it to the end of the case? I've never heard of that.
Yeah, well, I guess what you could do is they could hear the arguments, and then based upon the arguments, maybe resurrect the motion to dismiss prior to making the decision on the ultimate case.
That's fine. I want to move this a little. Having said that, what's interesting is that, and I think I'm correct in saying this, is that whichever way this council decides this case, both Mr. Hollop and I will still have the opportunity to file the prerogative writs.
That's my point. The point is the argument. You're right. The argument doesn't get lost if either party decides to appeal. I just think it, and I understand, Mr. Hollop, it puts this board in a difficult situation because they're not judges. I mean, they don't entertain motions to dismiss, let alone these types of hearings, and it's not contemplated in the statute or in the ordinance. So I'm not even sure about the appropriateness of it, frankly. Given, look, you're not attorneys. I happen to know a little bit about motions to dismiss because I've been on both sides of that argument, but you're not. And so that's why I'm trying to give you my thoughts as to whether or not it would be appropriate. My first argument is that the motion to dismiss in this type of hearing, that type of procedural issue probably isn't appropriate, but it's before you and it's an issue to be resolved. Look, I think if you feel comfortable ruling on it, hearing what the arguments are, you can do a roll call on the motion to dismiss right now, and then if it's no, then it's no, and you have it, and then if it's yes, we don't need to get to the second part. So I think it kind of makes more sense, to go through roll call if you feel comfortable with it. Does anyone
Can you just
not
make it
does
clear?
anyone not feel comfortable proceeding with the motion to dismiss issue?
No, just to make it clear which way,
Does anybody have any questions to myself or council on the issue?
Okay, so everyone on the council is clear on what we will be voting on.
So the issue is, right, whether, the question is, the motion to dismiss has been proffered. A yes vote would be to grant the motion, and no vote would be to deny the motion.
Thank you very much.
So
And
when you, well, right, so the motion is whether to grant the motion to dismiss.
So that would mean if we vote
Yes,
yes, then,
Yes is for
then we're not
dismissal.
going to hear the hearing and that's it, okay.
and you're dismissing the case based upon the procedural aspects raised by Mr. Holland.
so then you can call the roll.
No.
Mr. Desai is absent. Mr. Garcia?
No.
Dr. Greenberg Galai?
No.
Mr. Paschetti?
No.
Ms. Walker?
No.
Council President Sohar?
No.
We got that addressed.
So we're ready to move on.
Now we're ready to move on.
All set to go?
Now we're set to go. So at this point, being that the appellant filed the appeal, Mr. Gazarovski, in addition to the written arguments he submitted, will now proffer his oral argument in support of his client's position. Thank you.
Okay. Thank you, Madam President, members of the board. I've listened to the comment of Mr. Roselli with regard to the process taking place. Closer? I've been practicing in New Jersey for probably over 50 years, and I'm proud of that because it means I'm still alive. Years ago, most all municipalities had this provision with regard to your taking an appeal to the governing body. As years have gone by, probably Old Bridge is one of the few remaining communities that still has this provision in their ordinance. I think in all the years I've practiced, I've been involved in a procedure like this on one occasion. Having said that, I'm kind of, in my own mind, unsure of the efficacy of the ordinance because no matter who loses, they can still go on to the Superior Court with a prerogative writ action. And that's probably why in many instances, that's what an appellant will seek to do. Having said that, I think that because the board has the transcript, you're aware of the facts of this case. For the record, I would simply want to point out that the applicant, before the Zoning Board of Adjustment, made an application for a use variance pursuant to 40:55D-1, as well as a density variance pursuant to 40:55D-70D5. The property in question is located on Route 34. It's in the OGI zone, which specifically does not permit a residential use. The vote in question was a 5-2 vote, and of course, I'm sure you're aware of the fact that for a zoning application for a D variance, 5 votes are necessary. This was a 5-2 vote. It was an affirmative vote. At the hearing below, Mr. Titino, who I respect as a practicing attorney in the state of New Jersey, and I think is a gentleman, made application and he represented himself. My client, who is a layman, was not present, did not hire an attorney. There was no one present to oppose this application before the zoning board, and basically it went through. Mr. Titino owns the property, and he presently has his law office on the property, and what he's seeking to do is to basically demolish the existing building, reconstruct a new building with offices of whatever nature they may be, perhaps including his present office on the first floor, and having 4 residential apartments on the second floor. There are 33 parking lots also provided. As Mr. Roselli also pointed out, this was a bifurcated application. And if you're not familiar with that, when one is applying for a use variance, he has the right to seek a bifurcated application, which means that he initially goes before the board with a set of plans, presents testimony, and gets either an approval or a denial of his application. Sometimes the applicant has various reasons for doing that. In most instances, when it's a large project, sometimes he does it to perhaps hedge his bets with regard to the expense of preparing site plans and all the other things. This particular case, I think that was all done. Mr. Testino sought to first get a decision with regard to the use variance. I, of course, have submitted a letter, and I have also reviewed the letter of my colleague who's seated to the right of me, and I think that while we may disagree about many things, what we do agree upon is the fact that the seminal case in the state of New Jersey is the Medici case. Every attorney who practices land use and appears before boards is familiar with that case. And the case really came about because there was a lot of confusion or misunderstandings as to what, in fact, was the criteria to be established when one was seeking a use variance. And in the Medici case, the Supreme Court pointed out very, very clearly that use variances have to be treated with a degree of, I think you may use the word suspicion, but I don't think it is suspicion. I think a person's motives can be purposefully clear and honorable in seeking such a variance, but the Medici court said that zoning boards of adjustment have to look at this application very closely, to look at all of the facts which are presented and base their decision upon the criteria that they set forth. In this particular case, there were a series of witnesses, not a series, well, a series of witnesses who were called by Mr. Sestino. I would submit to the board that the only witness who is of consequence was that of his planner, Mr. Osiello, and his testimony begins on page 42 of the transcript. And I've read through the transcript several times. I have been practicing land use for the last 30 or 40 years. I've argued numerous cases, both in Superior Court as well as the appellate division, and we who practice type of law are all familiar with what is necessary to sustain a case for a use variance. It's my opinion, others may differ with me, that when in fact a objector before a zoning board of adjustment is successful in overturning an approval, it's virtually a lock that that cannot be overturned. That is not true when an applicant before a zoning of abortion receives an approval. That is looked at by any reviewing authority with close scrutiny. Normally, this would go before the Superior Court. This particular case, my client chose an intermediate review by this governing body. Having said that, the only real consideration that can be given to anything in a case such as this is the transcript. Now, if in fact we were going to Superior Court, both counsel would submit briefs of varying pages. In this particular case, probably between 20 and 30 pages. We all know that lawyers like to be verbose and sound very intelligent in appearing before the Superior Court. But in this case, what you have before you is basically a nuts and bolts review of this approval. You will know all about this case as to what it's about by reading the testimony of the planner, which begins on page 42. And I've read through that transcript several times, and I'm not belittling Mr. Orsino, but I think that any testimony he gives was sparse, if anything. The first thing which he puts before the Zoning Board of Adjustment, he testifies as to the location of this property, and he says that it is unique. It's unique because it's narrow and it has great depth. Well, what does that have to do with whether or not you get a use variance to have apartments there? It means absolutely nothing. You could have a tremendous tract of land and look for the same variance. What is unique over the fact that you're looking to put a residential use, two uses, office on the bottom, residential on the top, and the property is narrow, but having said that, it does accommodate 33 parking spaces. The next thing he speaks about with regard to the uniqueness of this property is that it's adjacent to a firehouse and it's adjacent to a first aid squad. Once again, I think that we could draw upon our history and say that usually the only place where apartments or residential uses exist adjacent to such uses are in cities, whether it be Newark or Bayonne or Perth Amboy and or the like. Clearly, Old Bridge is not that type of a community. Old Bridge is a community where as time goes by, we have large residential homes, we have small residential homes, and the planner for the board pointed out in her testimony that the governing body was of the opinion that there were a sufficient number of residential uses in Old Bridge and was discouraging any increase in them. Now, Mr. Osiello also pointed out that because there's an easement in the rear of this property, basically 2/3 of the property was unusable. Once again, what does this have to do with the special circumstances or reasons for the granting of a use variance? So in a nutshell, what we have is it's a narrow and long piece of property. Number two, it's adjacent to a firehouse and a first aid squad. And when one of the members of the board commented that, well, wouldn't that be disturbing to any residents living there if in the middle of a night the sirens went off? And the response from the planner was, well, I guess they wouldn't rent an apartment at this particular site. Well, how does that in any way establish the criteria for granting a variance for residential apartments? If anything, it's just the opposite. Now, when we both referred to the Medici case, it's clear what it says. The only thing that we talk about here is the fact that there certainly is access to this property for use of residential apartments. However, you also have access to every other type of use that you might want to put on this property. In addition to that, this is not a large complex where you would have it set back away from the highway, but rather it's right up there on front. So any and all traffic or noises from the highway are going to impact this building. So in my letter brief, I referred to the OG zone, and there are a number of similar properties located on this highway. So if in fact this particular use variance is sustained, you once again are opening up the door to other applications coming in seeking the same relief. Having said that, if that in fact is what the governing body of this municipality wants, then what they should do is instruct their planner to go back to the drawing board, instruct the planning board to come up with a new master plan or a new reexamination of the master plan. Now, in this particular case, when there was testimony or whatnot, your 217 master plan in the reexamination of May of 2020 includes the following recommendation for the OG zone parcels, which recommendation was adopted by this governing body. Now, council tries to make an issue that in some ways my council made a misrepresentation with regard to what the planner was saying. But here you have the master plan, reexamination of the master plan. They are put together by your trusted professionals, whether it be your engineer, your traffic consultants, your planner, and the like. And what it says in that reexamination is, and I quote, "With changing market trends and development needs, the structure of the current general office zones shall be evaluated for alternate non-residential uses. The OG zones were once areas where small, moderate, and large office plexes were to be developed to the ease of access to highways and commuter access points. Few of the zones, however, were ever developed with office use." Well, having said that, if someone could explain to me how, when your master plan and your reexamination of the master plan were adopted by the governing body, where it said should be evaluated for alternate residential uses. Now, if that was the recommendation of the master plan and the reexamination of the master plan, they should have said should be evaluated for alternate residential uses. Your governing body, meaning you, did not change the recommendation of your planning board. You allowed the property in question to remain non-residential. And I read my learned colleague's comments with regard to attempting to deal with that issue, and it's almost like the old joke, you could run, but you can't hide. You can't run from what this says. You can't run from what your zoning ordinance says. And if you, in fact, affirm the decision of the zoning board, then that basically almost has a carte blanche for the remaining property owners on Route 34 to come in for the same exact relief. When you read through the transcript, and I would draw your attention to the comments of your planner, Ms. Schwartz, and it begins on page 55, because at the conclusion of the hearing, she was called upon for her comments. On page 56, she says, and I quote, "When the township adopted its economic development opportunity zone, the master plan, that reexamination had specifically, the planner had just suggested that they should consider adding residential uses on the commercial, but that was turned down by the council because of the numerous apartments that have already been approved but not yet built. So in terms of that, the pulse of the town has been that we don't want more apartments in the town." Now, that's in the transcript of the zoning board hearing. How much clearer can you get than that? So that, for the most part, would be my concluding comments. But my argument is, if in fact this council believes that this particular zone should permit residential apartments, it's very simple. Go back to your planning board, seek a reexamination of the master plan, and if in fact they have changed their mind, they can bring that to your attention. You can also vote in a manner to establish a new zone that is not in compliance with your master plan or the reexamination of the master plan. That calls for a special vote. So here, this is what we have. We have the plan, the reexamination of the master plan, and at this particular hearing, you have your planner pointing out to the zoning board that the governing body has made a decision that there are sufficient apartments in this municipality. Now, having said that, obviously, the zoning board voted 5-2. And, you know, it's a home run, whether it's by inches or a country mile. That's how they voted. And having said that, that is my client filed an appeal. I would ask you to follow through with what you have previously legislated with regard to the zoning, and the decision of the zoning board should be reversed. Thank you for your patience.
Thank you, Mr. Zelli. To start, I think it's important to note that this application that was before the zoning board back in July included not only the application, which had surveys, case impact, community impact statements, exhibits, architect sketches, things of that nature, a plethora of information. And the hearing, you know, itself is about 75 pages or so in total. On the transcript, and I would implore the council to review that, okay, and digest that. It's not something you could read in 5 minutes and just, you know, get a understanding of. Part of the reason why the submission that I had provided to the council was a little bit lengthy. I try not to go too crazy on things like this. It was really to give the council an understanding of the amount of information that was provided at the time of the hearing. As my colleague had indicated, probably the primary witness that was heard that night that is important to this matter is the applicant's professional planner, Justin Auciello, who had provided extensive testimony pertaining to, again, as my colleague indicated, the Medici case, which is a Supreme Court case back from the 80s that does set forth the standard for the granting of a use variance. But that's not to mean or to say that the other witnesses, that included the applicant himself, who provided testimony with respect to what the application is about, the surrounding areas, what's expected to come about, and an explanation of how the building will be used, which really, as it is right now, there's a office building there that houses the applicant's law firm. Okay, and he's been in that building for approximately 34 years. He's been practicing for 37 years. And as you read the record, you'll see with the progress of time, there's been expansion of business and the need to expand the office building. And again, there's indication in the record below that in 2019, he went before the planning board to increase the size of his building, which was granted at that point in time. He had, you know, similar studies that he presented concerning traffic impact and things of that nature, which there was testimony at the below hearing that the traffic is going to be less impactful because you're not going to be a total office building. There'll be some residential, and there's going to be a decrease in coming and goings of people during the peak hours in the morning, and went from 14 to 9, and then in the evening, very similar, I believe it was 14 to 10 or somewhere around there. But I digress. Going back to the point I wanted to make, the other witnesses do and are important, and they include the professional engineer that was provided testimony that evening, who's Ernest Feist. Okay, he's also a professional planner and certified municipal planner, but he wasn't brought in for any of those reasons except for the engineering part, and he did provide testimony about the engineering plan of the property and what they could expect. But again, as Mr. Roselli and Mr. Gazarovski had pointed out, this was a bifurcated application. So any engineering issues or other variances would probably be reviewed at the site plan review with the Township zoning board. The last witness that was also there that testified was the architect, who did provide some information as to the look and the feel of the building and what you could expect. And really what was proposed, as it's set forth in the record below, it's a two-story building with the first floor being office space with 2 offices, one of which is going to be the client's law firm practice, okay, and the other side, not sure what it's going to be there because we haven't built it yet, we don't know, but there was indications and representations board's inquiry that it would not be used for or be limited to non-medical use, just to decrease the impact, as medical buildings tend to have more of an impact on the property in the area in terms of parking and usage. Above that, as indicated, there's going to be 4 residential units, 3 of which are intended to be a 1-bedroom unit, and the last one being a 2-bedroom unit, which caused the need for the use variance, both for the use, because as my colleague indicated, this is an OG1 zone, which is primarily for office space and things of that nature. Residential units are not permitted in this area, thus requiring the use variance. With the use variance, as there would be residential units there, that's going to increase the density requirement, which is 0 for the zone, and it goes up with the 4 residential units, thus the need for the density variance as well. To address the concerns of the appellant's argument that, the planner had testified to about the uniqueness of this property with respect to its deepness, okay? It's not as wide as it is deep, okay? That there's the Old Bridge First Aid when you're facing the building to the left of the building, and then you have the fire department to the right. I don't believe the point, and if you review the record, that it's unique because of that. The uniqueness is really that, looking at the Medici case and the requirements that the applicant/respondent here is supposed to prove, one of the portions it needs to show is the positive criteria, the special reasons, whether or not this property is properly suited for the proposed use. Okay, it's important to note that the testimony from the planner was this property is in fact suitable for the proposed use of office space, which is a permissible use there, as well as for the second unit or second floor residential units. Also looking at the issue of the positive criteria, there was testimony with respect to the proposed use would advance the purpose of the municipal land use law, as well as the township's master plan and the zoning ordinance. In the brief that it submitted, it outlines specifically where the planner, actually, no, it doesn't, my apologies. It indicates what the arguments were and what the information that was presented by the planner to prove these points. If the council would like, I did go back after I had submitted this paper to you, and I indicated what pages you could find this information on. So if you want me to read it out to you and you can mark it down, I'd be more than happy to do that. But going back to the reasons that were provided by the planner for the fact that this proposed use would be suitable for the property. Okay, there was testimony that the site could accommodate the proposed use from an engineering standpoint. There is sufficient space available for the site redevelopment, and the site will function in a safely and efficiently manner. This information really is found on pages 44 to 46 of the planner, as well in the earlier testimony of the engineer. The site's location was testified to be ideal for the mixed use, as it will be oriented to Route 34, which is a major highway or regional highway. And again, it's near the emergency service building on the right, which is the fire department, and left, which is the first aid. And the use or the proposed use of the site would have no impact, as testified to by the planner, on either of these properties adjoining it. There was also testimony presented, and again, this goes to, I guess, the uniqueness of the property being so deep, testimony from the planner that because it's so deep, the majority of the development would be on the front end of the property, with the back end having the conservation easement, as well as a wooded area, which abuts residential properties behind it, would be left untouched. This was a positive thing too, as well, because it wouldn't disturb the neighboring people behind them. That was testified to by the planner. And once again, the planner had indicated that as the site's located on Route 34, the full modern redevelopment of this property would be in a highly visible location, which would also be a public benefit. In going on, the planner had also indicated that how the municipal land use law would be promoted by this proposal. And in reviewing that, he had indicated that under NJSA 40:55D-2, several of the proposed uses would be advanced, and he'd indicated that and I'd marked in my paper that it was subsection C, E, G, I, and M. I think it's important to note that the ordinance and the statutes do make provision for an applicant or property owner to come before the zoning board to request use variances as a way to use their property in a meaningful way when the zone wouldn't allow it normally. I think it's also important to note that with the introduction of the residential units on the second floor, and the fact that my adversary had argued that the planner and the master plan had indicated that they did not want any further residential units in the OG1 zone, I think it's important to note two things. First, that recommendation was from a 2019 reevaluation of the master plan. Second, the suggestion that was made that with market changes and trends and things of that nature, it's all right to look at the zones every once in a while to see what needs to be updated. Recently, as everyone is aware, we hit an epidemic and a pandemic, starting in March 2020, where we see a trend, and my client had submitted with an application, a New York Times article, where office space is not as in high demand as it once was, with many people now doing Zoom and things of that nature. So looking at it from that perspective, I think, a request or an application for a variance was not out of line, was not over the top or egregious. It was what was appropriate for that point in time. Just to get back to the Medici case, which really sets forth what is required to be reviewed and satisfied in order for a use variance to be granted. The case also talks about what's called negative criteria. I'm not sure if we all know what that is or not, but sometimes it could be.
I'll interrupt you, but I think it would be important, and since you're doing it now, I was going to wait, but if you can advise council what the standard is under Medici to grant.
Sure, I think I might have jumped ahead of myself. So,
right,
just
so because. They're not a board, right? So they don't hear applications. So there's a lot of parlance that you're utilizing that typically they won't hear. A zoning board would, or a planning board would, right? When you're talking about special reasons and the reasons under land use law. So I think it's important to first establish what you believe the standard is under Medici to grant a use variance, so that, and then I think that would be, go from there and then go into the positive and negative criteria.
Absolutely. Just to rewind, and I did kind of go over the positive criteria. Under the Medici case, the Supreme Court said a zoning board should look at several aspects. One, they coined and determined to be what's called the positive criteria or the special reasons. The questions that a board should really ask in determining whether or not the positive criteria has been met and satisfied is, one, is the property suitable for the proposed use? Two, whether the proposed use will advance the purpose of the municipal land use law. And three, whether the proposed use will advance the township master's plan. And four, whether the proposed use will advance the zoning ordinances. You had heard, sorry, I'm not going to go back and repeat it. It's stated in the brief, but earlier there was argument presented, okay, and there was in the hearing transcript record, arguments presented by the professional planner indicating that this property was well suited for the proposed use and that the use was in line with not only the master plan and would advance its purpose, but also the municipal land use laws as well as the zoning ordinances. The second part that the Medici case had indicated needs to be reviewed by a zoning board in order to grant a use variance was what's called negative criteria. Negative criteria, when you're reviewing that, you're asking yourselves whether the variance can be granted without causing substantial detriment to the public good, whether the variance won't substantially impact the intent and purpose of the master plan, and whether the variance won't substantially impact the intent and purpose of municipal zoning ordinances. So it's kind of not the invert but the convert, I guess, of the special reasons positive criteria. Again, in this case, the professional planner, Justin Osceola, had provided a lot of testimony regarding the negative criteria and how it was his belief, and provided examples how the variance could be granted without substantial detriment to the public. As well as, well, just to flip real quick, I don't want to go back and forth. If you turn to pages 50 to 51 of the hearing transcript, Mr. Ossio testifies to that fact and indicates that if the variances are in fact granted, there would be no substantial detriment to the public good. He had predicated this opinion based upon the next two questions of whether it would impact, the variance would impact the intended purpose of the master plan or the zoning ordinances. And if you look at the hearing transcript, you could find his testimony with respect to the master plan at pages 47 and 48, okay, and whether they impact the zoning ordinances or zoning plan on page 49 to page 50, okay. And in reviewing the master plan, you know, again, we revert back to the comment that was made by the township planner wherein the May 19, 2020 report had indicated with changing market trends and development needs, the structure of the current general office zones shall be evaluated for alternate non-residential uses. The OG zones were once areas where small, moderate, and large office plexes were to be developed due to ease of access to highways and commuter access points. Few of the zones, however, were ever developed with office use. The last sentence there in the report is important because there was never, the goal of this plan was never satisfied. It was never met, okay? And it being released back in May of 2020 versus what's going on in 2021, there's been a change or a shift in trends and a marketability of certain areas. With that said, that goes back and it kind of dovetails into my argument with the fact that the below board heard on the record that, you know, even though this is office space and we need a use variance, there's a change in the market and a change in need, you know, for the trends and what people really want out there. Again, looking at the negative criteria and asking ourselves whether or not this is going to impact the zoning ordinances in the master plan, we look toward the municipal ordinance section 250-2, which sets forth the purposes of the zoning ordinance. Okay, and in reviewing that, there was testimony provided by the planner to indicate that several of the purposes required or stipulated in this ordinance would be satisfied and advanced. And looking at the information provided in the record below, there's no doubt, and there's several things, and I'll read them off briefly. Municipal Ordinance 250-2, sections C, E, G, I, X, and double B, where C indicates to provide adequate light, air, and open space. Okay, testimony from the architect as well as the engineer indicated that this development and this proposal would provide adequate light, air, and open space. Section E indicates it's to establish population densities and concentrations, which provide for a moderate increase in the existing rural and suburban areas of the municipality so as to avoid scattered development and premature construction of public facilities. 2, will contribute to the well-being of persons, neighborhood communities, and regions, and the preservation of the environment. And 3, are consistent with the character and density of surrounding developed areas, topography, adequacy of circulation, and other community facilities. Okay, I think this one's an important one because there was testimony that, you know, we have an OG zone, we have a fire department on one side, an emergency department on the other side, and in the back of it, we have residential zone. Okay, so in the preliminary area or the reasonable area, we have a variety of uses. The use that was proposed, it's not outrageous, it's not radical to a shift in the plan or the master plan because it provides for the office space as well as several residential units. Looking at section G, quickly, that's to provide sufficient space in appropriate locations for a variety of uses in open space, both public and private, according to their respective environmental requirements. Again, there was testimony from the planner that the property is suitable for the proposed use. Section I indicates to promote a desirable visual environment through creative development techniques, good civil design and arrangements. If you look through the record, there was definitely testimony from the architect as to the look and feel of the building. There were questions and concerns about whether the building looked too commercial if it's going to have residential and how it could be toned down, but there was indication and testimony that the look and feel of the property does fit into this area, and because it's going to be modernized, would be a benefit to the public good and public use. Section X indicates to encourage the rehabilitation of existing commercial areas with particular consideration given to the issues of curb and landscaping, front and rear facade improvements and buffering through the use of creative design standards. Again, not to beat a dead horse here, and I will move along, everyone's been patient. There was testimony provided in the record below indicating that the use and design of the landscaping would fit in this area and would provide a new modernized look to everything. Again, really, I don't want to go by bit, and I can't stress the importance of the board reviewing what information was provided at the testimony by the witnesses, especially the planner, because it's our position that a lot of information was provided to satisfy the Medici case, okay, to show that there was special reasons and positive criteria, as well as the satisfaction of the negative criteria. Again, looking at the issue under the negative criteria, whether or not this would substantially impact the purpose of the zoning plan, again, I understand my adversary is arguing that there's supposed to be less residences here. However, as the report indicates, we need to look at the market trends and the change, and there's been a shift. And if there's going to be a shift, then we have to see what's available and what can be done, and whether or not the proposal meets other qualifications and requirements. I think it does, and there was extensive testimony provided by the planner. If you look at page 49's line 16 to the end of that page, there was indication that the zone plan would not be impacted by this, and I'll highlight a couple of the big ones. Going back to the 2002 master plan, there was testimony from the planner that, the OG1 zone does permit hotels and motels in that zone. These are considered commercial properties that are permissible. Although they're not residential uses technically, there are transient people and dwellings that stay overnight for these types of places. So considering what the residential units would do, this is not so far off and that outrageous or egregious where it couldn't happen or wouldn't happen if other requirements were met under the Medici case, which they were positively shown by the record below. Again, just looking at the purpose of the board and the fact that it has the opportunity to review this application from a de novo position of the record below, indicating that you're allowed to review it and come up with your own determination. I would just like to stress and to remind the board that under New Jersey statutes, it's NJSA, 40:55D-17E, any decision by the board must be by a majority of its full membership to either reverse or remand or to add additional stipulations or conditions. This has been interpreted by several courts that there is a presumption that the zoning board granting the variance is correct. Without the majority vote of the full board members, to reverse or remand this, the grant of the variance would be correct and would stay in place. I think it's important to note that the zoning board is comprised of members placed on it by this governing board, and that it's important that the board and this governing board retains faith in their zoning board members with the job that they've been entrusted to do by council. With that said, I would just request that the board reviewing this matter de novo approve the application as it has been presented based upon the plethora of information that's been provided below and the letter brief that's been submitted here, kind of directing you to the information in the record below. Thank you.
May I have
Thank you,
brief
Mr. Howell.
response?
Certainly, Ms. Gazarovski.
Thank you very much. Madam President and members of the board, my first comment would be, with respect to my colleague, that much of his argument was his testimony rather than referring to what was said by the planner. Having said that, we all acknowledge that the landmark case is Medici. We also have to acknowledge that the testimony before the board by Mr. Testino was that he has owned this property and utilized it as his office for decades. Having said that, he owned the property when the master plan was passed. He owned the property when the reexamination of the master plan was passed. If he disagreed with the arguments put forth before the planning board in their decision, he could have filed a prerogative writ suit challenging that. He did not. Instead, 1 year after the reexamination of the master plan is passed, he comes before the zoning board seeking relief for a specific piece of property rather than challenging the zoning ordinance itself. Also, with regard to the zoning in question, it would not render Mr. Testino's property inutile. Inutile, it's a word I learned a long time ago, but it didn't make his property not usable. He's having 2 office facilities on the first floor. He certainly can have 2 additional offices on the second floor. There's no testimony from this planner that such a use, which is permitted, would not be acceptable or successful in this property. Lastly, I want to read and perhaps paraphrase in some ways the decision of the Medici case, which laid out use variances granted to individual property owners to allow commercial uses otherwise prohibited in the zone are inherently suspect. In the Medici case, it was a commercial use, not a residential use. The concept is the same. The court emphasized and re-emphasized that the MLUL has provided the proper tools through annual reports to the governing body and the master plan and periodic reexamination reports by the master plan for the governing body to establish zoning rules for various zones and districts by careful planning and proper zoning regulation. This process is to be done by the governing body through adoption, amendment of zoning regulations, not by ad hoc use variance applications affecting only one property in a zone or district of many properties similarly situated. That process, zoning by governing body ordinance, also allows for and result in broad study by the planning board, substantial input by the public, and proper consideration of the broader impacts of the change or use proposed. I mean, that's what the Medici case says. And that's what should have been followed by the zoning board. They had before them an application for a use variance for one specific piece of property, an application that was brought approximately 1 year after the reexamination of which once again established the fact that there could not be residential use in that zone. That reexamination report was accepted by the governing body and it wasn't challenged. So here we have an applicant coming in. It's not a person who's a contract purchaser. He's a person who owned this property for many years. He knew exactly what was going on. He chose to do nothing. He goes before a board and comes away with obviously an approval. It's our position that was a mistake, and that was why my client filed this appeal. Thank you.
Just briefly, I think it's important to note that the way the municipal land use law is set up, it permits use variance application, okay? And whether there was a 2020 reexamination by the planning board as to what continues with this property or not, may or may not be relevant to the council. And the reason being is that that use had been in place for multiple years prior to that reevaluation. So, you know, we could hypothesize as to whether or not a prerogative writ at that time would have changed anything. I don't think that's the point of the application and the point of what this board is hearing on appeal. The point being is the right to a use variance application is granted to any property owner, and that certain standards need to be met under the Medici case. And if you're able to satisfy to the zoning board and governing board satisfaction, then the use variance is granted. And that's what we see here in this case. Thank you.
Before we go further, do either of you want to address the density D5 variance? 'Cause
I'm sorry, address what?
the D5 variance, the density variance, since the statute talks about D variance, it's with a D1 and a D5. The criteria for the granting of a density variance is different than the use variance. We heard the arguments on the use variance.
I think, in all fairness, the granting of the use variance, whether or not that's permitted, okay?
Well, ultimately,
it goes, because if you look
I-
at the record below, they asked if they wanted to bifurcate that vote. And
They did.
yes, they did. So,
Right.
you know, at this point in time, well,
I'm I'm raising the issue if you want to address any aspect of it.
I don't want to address.
I think at this point, rely on the papers that have been submitted. I mean, it's very thorough, and I see, you know, everyone's
That's a
starting
very
to
good observation.
slow down a bit, so.
Figured I'd raise it. Council, now, if anybody has any questions, you can certainly direct questions to either council.
No comments or questions? Anyone on my right? Okay, no.
Anybody, if you guys have any questions for me, I'll try to answer them. Or in general, anything you want to discuss?
Any council member on my right have a question or a comment for Mr. Roselli?
I read the testimony and I read all the documents.
Your mic?
And our ordinance, it's on. And our ordinance and our zone land, so I think, you know, hearing both attorneys, I appreciate everything they told me, and I'll take it into account.
What's that? I'm sorry. Yeah, I didn't hear
So
you.
basically, after reading the testimony, the transcript, documents that were presented to me, listening to both attorneys, you know, I appreciate the arguments, and I'll take everything under account.
Okay, anyone else have a comment or a question?
Council want to deliberate? Do you have any discussion amongst yourselves with respect to the issues? Do you need additional time to review the record? I just get some feedback here.
Mr. I just have one question. So what are the options that would be presented in front of us for this? Obviously, it's yes, no, right? Those are the options, or?
The statute indicates that the governing body can vote. It says a majority of the full authorized membership. So for this board, majority is 5 because we have a 9-member board. So your options are you can reverse the zoning board's decision to grant the use variance. You can remand it back to the zoning board, indicating that hear it again. Or you can impose or alter conditions to the zoning board's grant as part of the remand. So those are your options. So if you don't do any of those, if you don't vote to reverse, if you don't vote to remand or impose conditions with the remand, then the decision is that you're affirming the decision of the zoning board. And if you don't get at least 5 votes for one of those 3 options or 4 options, that also would result in an affirmation. Or if there's a tie vote, that also results in an affirmation.
Mr. Pescetti, did you?
We should caucus a few minutes. This was a lot of information. How do we go about doing that amongst ourselves?
Well, you can. You have to do it publicly. You're a public board. So to the extent that you have questions and you can ask themselves, some of you, I think, have sat on boards before, the zoning board or planning board, so it's the same way. So when you caucus or deliberate, you deliberate in public, so that's part
No,
of it.
when you said that before caucus, I didn't know what you meant.
Yeah, yeah.
That's what we usually didn't say that word before. That's why I'm like, how do you do that? Okay, thank you.
I just wanted to make a comment. Can you hear me? I don't know if my mic is working. I've had an opportunity to read thoroughly over and over the testimony of everyone, and the thing that sticks out for me is our master plan was revised May 19, 2020, clearly states no residential in OG zones. I think it's going to set a very bad precedent for the area. The council doesn't want this. Also, the D variance for proposing the use is not permitted, the residential is not permitted in OG1 zone. I just think this is a violation of our master plan.
What else, Mr. Piscatty, you had your hand
Yeah,
up?
I basically have the same thing as Councilwoman Walker. Our master plan restricts residential units in an OG zone. We have a problem in Old Bridge. We have a problem of overdevelopment and squalor. And we as a council looked at the master plan and we knew what our problem was, and we confirmed in May that we don't want to change the master plan. I mean, we'll change the master plan when we think it's necessary. But just because the conditions change, or we have COVID or whatever, that doesn't mean that now we're going to put residential units in an OG zone. You know, the OG zone is for commercial, and that's what it's supposed to be. You know, if we start saying, okay, well, you can, build whatever you want in an OG zone, well, then everybody in the OG zone are going to want to do that because we're setting precedents. You know, so we review the master plan and we make sure that in Old Bridge, we're very careful. I mean, we can't do anything about stuff that's done 30 or 40 years ago, but we can do something today. And we can stand up for our master plan and say, this is what we want in Old Bridge, and we want to stick to it. So I personally think that the zoning board made a mistake, and they probably should relook at it. And that there's no change in this governing body's strategy. You know, we talk about overdevelopment all the time. We talk about areas in the town. We're very concerned. So we're satisfied with the OG zone, as far as I know. Thank you.
Before you continue, I just want to be clear. So it's reverse, remand, or affirm with or without conditions.
Can I ask a question? If it's reversed, does it goes to a judge, but if it's
No. I can't. No, if it's reversed, that means you reverse. Then at that point, you make a decision, and then the parties decide what they're going to do. My presumption is, I'm not going to presume. If it gets reversed, then the parties decide what they're going to do. If it gets remanded, any of those decisions, the parties can decide what they want to do. There's always the right to appeal by either of the parties. That's a right that both parties have.
Garcia?
If we vote to remand this, does that mean we have to come back to hear the case again?
Well, that's a possibility.
Is that possible?
I would imagine that's a possibility if it's going to be a remand.
Okay, thank you.
It's Dr. Greenberg, Belli?
Yes. So as we talked about tonight, our zoning plan, our master plan, that this is not consistent with the zoning plan and the master plan. And so it's not a permitted use. And going further, there's no bulk standards. There's nothing to compare this to. There's nothing in the area, as far as this type of use. And so it's really hard to gauge bulk standards when we have none. So I think, our master plan speaks for itself and our zoning laws, and we don't have standards for this. And I think that's, what I will take into consideration.
Anyone else have a comment or a question?
So we make a motion that we want to, how we want to proceed?
What's the next step?
Well, just make sure if, I don't know if anybody else, if any members have any other comments?
Well, I'll just make my final comment as well. I also reviewed all the information, and I really do think we have, we have a responsibility to this master plan. We're the ones that initiated this, and if, we start to deviate, I think it would be a problem too.
Are we done with our comments then?
I believe so, right? Everyone has commented? Oh, I'm sorry, Mr. Pescetti, I didn't see your hand.
I just wanted a clarification. If we remand it, that means it goes back to zoning and they hear the whole case over again? Or would they just read all the documents and then make another decision?
A remand would be typically would be they'd have to hear the testimony, present the case again. And unfortunately, just the statute just says remand.
Yes, Nana. Well, we have any more comments from the council members? If not, do we have a consensus of the board?
I'd like to make a motion to remand it to the zoning board.
I'll second that.
Could I be heard just
Yeah,
briefly
sure.
on that issue? I don't agree with the issue of the remand. I mean, it's very difficult to say why you're remanding something. If you've listened to this hearing, an appeal was taken saying that the decision was wrong. And if I would submit respectfully that if this board determines that the decision was wrong and contrary to the master plan and or the like, then the decision of the zoning board should be reversed. Plain and simple. If they could come in with a new application, they could come in with a modification, they could do whatever they wanted to. But if it's remanded, we're once again hearing the same case when you have found that the decision of the board was incorrect. That's my position.
Yeah, one thing I was just going to say is that, well, to the extent that you remanded, was the board intending to give any direction to the zoning board relative to the remand and what it is that they wanted to review? He said this is not, this doesn't happen very frequently. Mr. Howell, you can certainly respond.
If I may,
Yep,
and
sure.
I agree with my adversary. The notice of appeal was for an objection to the granting of the variance.
Yeah, but we need to.
Sorry
hear you.
about that.
Yeah.
As I was indicating, I agree with my colleague, Mr. Gazarovski. The notice of appeal was an objection to the grant of the variance. A remand of the matter back to the zoning board, I don't know what benefit that would provide to either party at this point in time. And then really the only effective way to resolve this matter is whether there's an affirmance of a decision or denial, or I'm sorry, a reversal. Again, I know the municipal ordinance and the statute is not clear and is very sparse on what a remand consists of, but generally we're looking at, and Mr. Roselli, you might agree with me, when you go to the appellate division, they usually remand and they direct the hearing court below. This is what you have to take more, information or and they direct them what they need to look at. Here, again, I don't know where we're going to end up if there's a remand. We just very, very well may be back here before this council again with the same issue. So I would request.
Right, to Mr. Howell's point, typically with a remand, what the courts do is, let's say they needed more testimony relative to a particular aspect of an application. Let's say they felt that the board didn't consider sufficiently enough some of the evidence presented. So the remand going back is usually with that type of instruction. I would agree with both counsel. I think at this point it's not a complicated case. I mean, it's a use variance, right? They presented the testimony. You know, the argument is, obviously from the appellant's point of view, is that they didn't provide sufficient testimony to support the grant of the use variance, right? That they didn't meet the requirements of the Medici Court relative to the grant of the use variance. Obviously, the applicant believes that the record supports the grant of the use variance. I think in the instance, but I think in this instance, remanding it back when it would be, nothing's really going to change. I think it would be a waste of time for the zoning board and the parties to that process. So I think I would counsel against a remand. I think this is really an up or down vote relative, because the issue is so narrow. It's just a use variance grant. It's not even site plan approval with it. So I think it's an up or down vote, if you want to proceed.
Then I'll rescind my motion to send to the zoning board.
What is the consensus? Do we have a motion? She has a motion to rescind.
I have an issue, okay? The issue that I have is that if we say that the zoning board was wrong and we just
You're reversing their decision.
reverse the decision, they could take it to Supreme Court,
Period. Well, they
or whatever. They could take it to court, okay? And knowing how they've decided court cases up there, they can overturn what we say.
Well,
Now, if we remand it,
I know, but that's always a possibility.
right, but if we remand it and it goes back to zoning, I mean, we can write a resolution telling the zoning board to follow the master plan like they're supposed to.
Well,
Now,
no,
I was on the planning board.
no, wait.
When I was on the planning board, I had to go to
Can I stop?
school, and in
Right.
the school, they told you your default is no. The applicant has to prove to you why they should get their variance. Okay? So
I understand that, but
I don't see that as a waste of time.
well, if you look at the record and the testimony that was presented, that was the issue to be decided, right? That was the testimony. That is the issue. So if you're going to remand it back to the zoning board, what is it that you're going to ask them to reconsider all the testimony that was presented again? And then the likelihood, and I don't know, but the likelihood is that, you can come out with the same vote.
Not likely.
Well, I don't know that. I don't know if it's likely or not, but I mean, it seems the board's there. Look, that's my counsel, but I think if you're going to advise, if you're going to vote to remand and say remand and then with the condition that you reconsider the application and the new testimony, I mean, I don't know what you're going to add on the remand.
Well, if we decide to say we don't agree with the zoning board's decision, do we have to make a motion, or is that just an up and down vote from us?
Same thing. I think, I mean, ultimately, again, the statutes didn't contemplate the fact that council met, 2 times a month or 1 time a month. This decision ultimately would be memorialized in a resolution. I think it's appropriate. And you're supposed to provide notice of the decision within 10 days after today's date. So arguably, we would have to come back and whatever your decision is adopt the resolution. So both parties will have notice of the decision, and we have the copy of the transcript. But just to follow the statute, that would be the next step.
Okay, then I'll make a motion to overturn the zoning board decision. I feel they did not follow our master plan. They're setting a very bad precedent.
So it'd be a motion to reverse the zoning board's grant of the use variance.
I'll second that.
Sorry, and second by Mr. Pasquetti. And we're clear on what the motion is, correct? To overturn, you said?
To reverse, it's a motion to
Reverse, I'm sorry.
reverse the grant of the
Wrong
use
verbiage,
variance.
yes, okay. Want to make sure everyone's clear.
Mr. De Palma?
Yes.
Mr. Desai is absent. Mr. Garcia?
Yes.
Dr. Greenberg Belay?
Yes.
Mr. Murphy is absent. Mr. Pasquetti?
Yes.
Ms. Walker?
Yes.
Council President Sohar?
Yes.
Thank you. Mr. Halbon, what's the time frame to get a transcript, do you know? All right, I'm just, because I,
Find out, I'll let
all
you
right,
know.
if you could, because I just have to formulate a resolution.
Right, and you,
All right, and then, right, it'd be helpful for me to have a transcript relative to that. We have a 10-day window in which you're supposed to receive notice of the decision, even though you have it orally, but typically I've done before, I've memorialized it, have a memorialized resolution. Mr. Gazarovski, I think once that's adopted under the statute, you're required to publish a notice of decision.
Okay, fine.
Okay.
I'm happy to do that, obviously.
So the other thing I would say with respect to council is we should schedule a special meeting between now, you have 10 days from now in which to, and I'll have to draft the resolution in the interim for adoption. So while we're here, you may want to look at that.
Within 10.
And then Maureen will have to say
Mr.
on
Just a question. When you adopt that resolution, in my mind, it could be extremely sparse. You're just reversing. I don't think you
I'm
have
an
this-
attorney, I'm verbose.
Yeah. Right, I said that.
Right. Well, it'll be much not as detailed as a
Right.
planning
That's
board
fine.
resolution,
That's what I'm
but
trying to
but I'll
say.
do the background, the
Okay,
the
that's fine.
district, right, and then, I mean, ultimately,
All right, fine.
it's a memorialization. So if we can come up with a meeting between now and then,
Okay, let's look at the calendar for that.
Oh, yeah, Jimmy. I think you can.
council, thank you for your,
Yeah, I was just going to say the same thing. Thank you very much,
I appreciate
gentlemen.
the board's
Thank
time,
you
Madam
all.
President, members of the board. Thank you very much.
Thank you.
Mr. Yeah,
Yes.
I'll let you know.
Thank you.
There was a lady,
While he's in Florida in like 75-degree weather, 90-degree weather. Oh, yeah, yeah, well, we're having a heat wave.
I understand. Years ago, when anybody couldn't afford to buy a house in Perth Amboy or Woodbridge, they came down to Old Bridge because there was still dirt
Is he from
roads.
Somerset or that area, I think? Yeah, because he was an attorney too as well, I believe. Because I get asked that every once in a while. But no, my family's from like Long Island, New York City area, and New Jersey. But they're all moved out of state, or majority of them have.
the 18th, what's today's date?
Today's the 11th. 11th to the 21st.
So you'd have to get notice out, publish it. What's the time frame to get a notice published? Noon when? Tomorrow? Right. Jeez. Doesn't have to be, could be at any time. And if people can't, you know.
Can we do it Zoom?
Arguably, you could if you wanted to do a Zoom.
This is just going to be the one thing, right?
It'll be the only thing on the agenda.
Yeah, so if we Zoom, it'll be a lot easier.
You still have to advertise because it's a special meeting. Well, I need time to draft the resolution and a transcript. I mean, and that, look, my sense would, oh, I'm sorry. Yeah, the 19th or 20th might be better for me. I'd probably the 20th would prefer. No, Thursday's the 20th. No, but you don't have to have it at night. It's a special meeting, so if you want to have it during the day, you can have it during the day. Right? I mean, you don't need to have it at night. Right. We'll do both. We'll advertise it virtually and in person. We can do both. If somebody can make it, they can make it, you know. So can we have a time so we can start putting the notice together?
5:06?
Yeah, I have a 7 o'clock meeting, but if I don't, 5 o'clock's probably better. 5 p.m., Thursday, 20th. Got it? All right. Now can we have a motion to adjourn?
Make a motion.
Second.
Motion by Mrs. Walker to adjourn, second by Councilman Piscetty. Yes, please.
Yes.
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 Yes, thank you very much. Good evening.